All right. Hello, everybody. Welcome on back to another episode. I'm very excited to have a close friend of mine here today, Mr. Joseph Boufadel from Salvador Boufadel LLP. So thank you so much for coming here today, buddy. I appreciate you taking the time.
Thanks, Joe, and thanks for inviting me. It's great to be here.
Yeah. So for those of you that don't know Joseph, today we're going to be talking about bankruptcy, all about bankruptcy, personal, business. We're going to learn why you do bankruptcy. We're going to learn why you shouldn't do bankruptcy. And we're just going to really get into the intricate details here. And as an attorney, this is something that I can just say blatantly that I don't know a lot of information about. And I think it's just a topic that a lot of people really need to be able to dive into so they can learn about it. And I really appreciate you taking the time to be here today to explain all these intricacies.
I'm happy to be here, happy to answer the questions. And I guess we probably should give a disclaimer that's not legal advice.
Yeah.
This is just a conversation between us.
Yeah, 100%. Look, we're just trying to give you guys general information. This is not legal advice. Always call a lawyer and ask your exact details for your specific case, because every single situation with an attorney is always so fact specific. And today we'll definitely talk about some examples and some things that maybe Joseph has faced. This is going to be an interesting one, saying my own name out loud the whole day. But talking about the things that you've faced and what you've dealt with, and just realizing that it's so fact dependent. And so when it comes to things like bankruptcy or anything that's serious with the law, always call an attorney and consult them and get specific advice for your specific situation.
Yeah, absolutely.
Cool. So for those of you that don't know Joe, he's been doing, what would you prefer, Joe or Joseph?
Let's go with Joseph so I can call you Joe.
Perfect. Okay, cool. So for those of you that don't know Joseph, he's been practicing bankruptcy law for 16 years now, and he's been a specialist in this matter, and he's going to be giving us a lot of information today. Is there anything that you want to let the guests know about yourself specifically in your career before we get into the journey of bankruptcy?
Oh, that's a good question. My journey to the law is always a little bit different than maybe a little bit more prosaic. So it's a little bit boring, but it's, I start off as a programmer. I wanted to be a programmer, and I decided, at UCI, I was like, I just don't want to sit behind a desk all day. And now I sit behind a desk all day being an attorney. So that's the fun part. But yeah, no, I realized I didn't want to be a professor or do anything like that. And I was like, well, what can I do with some poli-sci and sociology type degrees? Yeah. And I always thought law was an option. And so I went to law school. You go to law school in the hope that, you want to be a con law scholar or something, right? Everyone wants to do First Amendment. And then you realize like 10 people in the country do con law. And so you kind of find your way through bankruptcy find your way through law school of what you like and dislike, mostly what you dislike. And then as you practice, you kind of figure out what jives with you and what you like to do.
Yeah, I can agree. I kind of went through the same process. I worked at a couple different firms where they did different types of law, and I'm like, oh, I really hate that. I really hate this. I don't like that whatsoever. Like, dealing with family law, I'm like, everybody just yells and cusses at each other and hates each other. This is horrible, and I don't know how these attorneys do it in their entire life. I definitely can understand why suicide rates for attorneys can be so high when you're just dealing with people in the most miserable situations. And then dealing with criminal law, I remember specifically telling myself, there's two different types of people with criminal law. There's the people that make a mistake, they're sorry about it, and they just need an attorney to help them get out of it, maybe do community service. And then there's the people who are the real criminals, who are typically the bigger cases, and they have this horrible victim mentality that everything is everybody else's fault. They're like, no, it's the cops' fault. Oh, it's their fault. They did this. I'm like, you got caught with drugs, committing the crime on video. What do you mean it's the officer's fault? And then you're dealing with that type of personality. And so, dealing with different types of law, you're going to get different types of characters. And so finding something that really resonates with you. So why did bankruptcy law really resonate with you?
Yeah, so in law school, I didn't take a bankruptcy class. It's funny. It's like you take certain classes in law school that you kind of don't want to do that practice. But I externed for a judge in law school, and I got to see kind of behind closed doors of like how things work in bankruptcy. And bankruptcy is wonderful. I mean, they're there to solve problems. It's not just you fight with litigation. There's multiple tools in the tool set for bankruptcy, and usually the goal is to resolve a problem. And litigation is one way, and bankruptcy is another, and mediation. But it's a process to force parties to consent, to come together and try to work things out.
Got it. Yeah. I mean, at the end of the day, bankruptcy sounds like this horrible thing, but really what it's helping somebody do is alleviate debt when they're in a situation that they're not able to escape.
Yeah, I agree. So, I mean, you hear a lot of horror stories. There are horror stories in bankruptcy and so forth, but usually it's because, they read something off the internet or they have a family friend tell them something. You got to get good advice. And a lot of good bankruptcy filings and so forth are done. The work is done before filing. Most of the work is done before filing. So you really got to plan it out. You really got to, be prepared to discuss all your financials with your attorney and so forth if you're trying to file a debtor's case.
100%. And so, when it comes to bankruptcy, there's obviously personal and then there's business bankruptcies, which are completely different ball games, just from my limited understanding when it comes to this. But let's talk about what are some of the things that would lead to someone thinking about bankruptcy and wanting to file it? Or what are some scenarios that you see that usually lead to someone wanting to claim or not claim, but file for bankruptcy?
Yeah, the circumstances are always different. So, focusing on the individual as opposed to a business. So individuals, in California, in our area in the Central District, most of the bankruptcies are Chapter 7s. Those are personal liquidation bankruptcies. I think it's like 70% of the filings last year, mostly that. Usually it's some life event happened. You have a home, there's a lot of real estate in California, a lot of real estate in Orange County. Maybe you're behind on your mortgage payments and they're going to foreclose on your home. Usually that's a participating event that will require you to, if you want to save your home and you can't pay, that's one way to kind of buy yourself time.
All right. So what are some things that would lead to someone wanting to file for bankruptcy, especially a personal bankruptcy? And I believe that's called Chapter 7, correct?
Correct. So there are multiple chapters, but let's start with a 7 for a person. Yeah. So a personal bankruptcy, usually there's something going on, like their house is about to be foreclosed on. And so the lender, they got their notice of default, notice of trustee sale, and oh no, in 30 days they're going to foreclose on my home. What do I do? A bankruptcy it can be helpful for that. Other ways that, car repossession, maybe someone's trying to garnish your wages, judgment enforcement type things. Those are usually the reasons why people file. You can get into the more strategic reasons why people file. Maybe it's a family law dispute. We talked about family law before, and there's nothing more volatile than family law dispute that makes its way into bankruptcy.
Yeah.
So, sometimes people file before, the split of property, because then the bankruptcy court can redo if they want to. Effectively, they can look behind that judgment before it's entered and say, yes, I agree with this property division or not, or redo it themselves, under the code as needed. But for an individual, so a 7 is a liquidation. So maybe we should start with kind of the basics. The reason people want to file is because they get an automatic stay. So the purpose of filing is a stay is kind of what you get in bankruptcy that stops all collection actions. It means your creditors can't, they can't keep sending you letters. They can't continue suing you, enforcing it if there's a halt. And so that is usually the reason why people do it, because they get that immediate relief. From there, a Chapter 7, for example, what happens when you file is it creates a bankruptcy estate. So all your assets become part of the bankruptcy estate. In a 7, you lose control of the case in the sense, as the debtor, in the sense that there's a Chapter 7 trustee appointed. Chapter 7 trustee looks at your financials, looks at your assets, and their goal is to try to put together all the assets to sell or turn into cash to pay unsecured creditors.
Okay.
And so from there, we probably should maybe get into some more specifics of that, because I threw a lot of terms out there.
Yeah, let's break this down step by step. So what it sounds like when you get into a bankruptcy or when you need a bankruptcy, first there's going to be some major life event. And that life event can be you can't afford to pay your mortgage, you're going through divorce. Basically what it sounds like is your debts are higher than what you make and more than you can afford to pay. And you're probably getting to the point where you're drowning in debt and there's going to be no way to get out of it.
Absolutely. That's definitely one reason. And something else like your house is going to be sold and you want to protect it, or other things. But yes, that's exactly it. Or you stop lawsuits usually is another reason to do it as well.
Okay, got it. So for a multitude of different reasons. Okay. And then after that, you're going to go ahead and you're going to start the process of filing for Chapter 7 bankruptcy, which will stop basically people from claiming or from trying to collect the debt from you. Is that correct? You said that there's going to be a stay on that.
Yeah, there's a stay on that, and it funnels everything through the bankruptcy process. But the before filing a 7, we talked about before filing any case, the work has to happen beforehand. So you really need to plan with your attorney, a bankruptcy attorney, why you're filing, what the reasons are for. And the whole point of the process is you disclose to the world, because it's a public, your financial situation. In exchange for being an honest debtor and disclosing that financial information, we'll give you a discharge at the end. So the goal at the end of a bankruptcy process is to get a personal discharge, so the debts that you had are no longer enforceable against you.
Okay.
And so effectively have a clean slate as to your personal debts against you, and you can move forward from there. Gives you kind of the breathing room you need to rebuild your credit, rebuild your financials, and move forward with your life.
Got it. Okay. And you said that to do this, there's typically a trustee that's assigned to help with this process. How does this trustee get assigned, or where do they come from? Is this by the court, or is this somebody that you hire on your own?
Great questions. Help with the process or to help the debtor is kind of not necessarily the case. So the minute you file a bankruptcy, the state is created, and then a judge is automatically assigned. This is all electronic. And in that, a Chapter 7 trustee through a panel is automatically assigned. The trustee's goal isn't necessarily is not to help the debtor. Their goal is to marshal the assets together to see what they can liquidate to pay creditors, unsecured creditors.
Okay.
So that's the whole goal, and a lot of it goes into the structure of what did you file, what their investigation reveals, what you submitted under oath, what you exempted. Probably exemptions are a big thing in bankruptcy and planning, and once that happens, they can figure out whether they need to pay anyone or whether it's a no asset case and whether you should get your discharge or not. But it's a public process that has significant deadlines, and it's all filed online, and you have to go through the structure.
So what exactly, for layman's terms, for a person that doesn't know what the word discharge means, what does that mean, and what do they need to understand about it?
Yeah, it's a great question. The discharge is the ultimate goal that you want as an individual debtor in a bankruptcy case. The point of it is to effectively wipe out your debts, your personal debts. They're not technically wiped out, but we say it's wiped out in layman terms. They're effectively reduced to zero.
Okay.
And that's the goal. So if you had $100,000 in unsecured debt, you get your discharge, that debt as of that date, uncollectible now.
Okay.
You get a clean slate.
Okay, got it.
So that's the goal.
And so when it comes to discharges, when you're explaining this stuff, right? Like, let's say, I just want to make up a scenario. So let's say I live in a home, right? And I can't afford to pay off my debts, which were credit card debts and a bunch of other debts to other people, but I want to keep my home, right? Mm-hmm. But the truth of the matter is I owe all these people money. Is there a scenario where I can still keep my home that I live in and keep making that payment and discharge the other debts? Or is it because I own this home, let's say I have some equity and there's some asset in it, do I lose that automatically because that's something that I could use to pay those debts?
That's a great question, and that situation comes up all the time. And unfortunately, it does come down to the specific facts. So we got to put some numbers on it, which hopefully doesn't glaze everyone over. But yeah, so California has a high homestead exemption. So let's say you have a $1 million home, you owe $500,000. So there's $500,000 in equity.
Okay.
Absent an exemption, in theory, that can be sold by the trustee to pay, to net $500,000 minus costs and all that. To then use that money to pay unsecured creditors.
Got it.
After, of course, paying off the first.
Okay.
But in California, we have a high homestead exemption as of the last few years during COVID. And so in Orange County, I think it's something like 700,000 index of inflation every year. So I think it's around 722 or something like that. So in that situation, where you're talking about, you have $1 million home, say a $500,000 mortgage, so there's $5,000 in equity. That homestead exemption protects the rest of the equity. So the trustee cannot sell your home to pay unsecured creditors.
Got it.
However, the caveat is the lender, if you're behind, can still foreclose on your home.
Okay.
Right? So the bankruptcy stay protects the lender from foreclosing then, but they can get what they call relief from the automatic stay to say, hey, the debtor who's behind on their payments, 12 months, hypothetically, they have no ability to pay, and so we want to continue with the foreclosure process outside of bankruptcy.
Okay.
Because it's not going to be useful for bankruptcy because you can exempt everything.
Got it.
The courts will grant that if it follows the correct procedure and the correct, elements for it. But as a matter of course, the lender will be able to foreclose on your home if you're not able to pay it, and they want to. Now, whether they want to or not is a separate question in the market economy and so forth. But to answer your question, yes, you can protect it, at least from the trustee selling it. Now, that segues, so the interesting thing is most people want to protect their home.
Yeah, for sure.
So a 7 is one way to do it.
Let me, before we go, so I just want to make sure I understand. So it sounds like in California, we have specific laws that are protecting us in regards to our homes. And it sounds like the law was passed during COVID. And so as long as you have less than 700,000 or whatever that number as it grows over time in equity, then you should be able to keep your home and you're not going to be forced to sell it by the trustee. Is that correct?
That's correct. And so to get a little bit more specific, so the homestead exemptions have existed for a long time, and they were amended to be very generous to debtors during COVID.
Yeah.
And they've changed the requirement so that it's like index for inflation. It's by county.
Yeah.
So whatever your exemption is in Riverside is not the same as Orange County because home prices are higher in Orange County. But it's the max amount effectively in Orange County. LA, I think, is close to the max, maybe the max.
Got it.
And so effectively, yes, you can protect it from the trustee selling, but whether the lender wants to sell is a different story altogether.
Yeah,
right.
Understood. Yeah. And that depends if you're making your payments on your home or what you're doing in regards to your debts. But of course, each situation is very fact specific. And of course, just based on this conversation, it's even more reason for you to always check what your specific situation is, because it's not just based on state, right? Like I didn't expect you to say that it's actually based on county, the amount of inflation, right? But it does make sense because in Orange County and Los Angeles, the inflation is going to be much higher than in more rural areas, right? So it's very important that if you're going through this process that you ask these questions. And so I'm sure just kind of like, perusing through this idea, I'm sure there probably are other specific exceptions, and I don't expect us to go through all of them, and I don't want to, but I'm just saying that, it sounds like you can protect specific assets. And I'm sure it sounds like the government is actually on our side and they want to help us out, which is great to hear that there are laws to protect us in that way. So that's actually relieving and makes me feel better that there is some, hope if somebody does have to go through a bankruptcy. That doesn't mean that they have to lose everything, and that there actually is a light at the end of the tunnel.
Yes, as long as you're honest and you fully disclose things and you plan it out correctly, you have options.
Yeah.
At least in the bankruptcy process. And a 7 may not be it. It may be a 13, which we can talk about later. But there are options to protect home and assets as long as you follow the rules and you get good advice.
Got it. Okay, and then I do want to go back to like the trustee, because I wanted to clarify that I understand. So this trustee is basically there to make sure that the government is getting their money, right?
The debtor and their counsel is
Yeah.
one bucket. And then let's say it's a 7, because the trustees are different and have different roles depending on what type of bankruptcy you file. The Chapter 7 trustees kind of quasi-governmental, but so they have certain protections. But their goal isn't to protect the government. Their goal is to collect the assets to the extent necessary to liquidate, to turn into cash to pay unsecured creditors.
Yeah.
That's their duty. They have other duties, of course, too, keep the debtor honest and so forth.
Yeah.
But that's their main one. It's not, say, to liquidate to pay the government. The government takes care of itself. Right, secured creditors like the bank take care of themselves because they have collateral.
Yeah.
Unsecured creditors, credit card debt, a personal loan, mom and pop, all that. You're in the same bucket, and so their goal is and they're at the bottom of the rung in terms of who gets paid what and when. Their goal is to protect those unsecured creditors. And then there's a U.S. trustee, and we don't have to get into that, which is a little bit different.
Got it. I guess the reason that I brought up, I thought of the government in my mind, because I figured when you do a bankruptcy, does it also discredit, can it also discharge your taxes owed to the government, or is that something completely separate and bankruptcy does not play into that?
No, it's a great question, and it can. There's a very complicated formula in bankruptcy for what it can and can't discharge in terms of the taxes and what type of taxes they are. But generally speaking, you can discharge old taxes as long as you file the return. If we're talking about IRS. Recent taxes, like within the first couple of years, you can't discharge those. The rules are complicated, but the answer is yes. But it depends on whether you file the return, and so forth. So there is a timing component to bankruptcy if when things are due. So the answer is yes.
It just depends on
like every lawyer question. It depends.
It just always depends.
Yeah.
Got it. Understood. Okay. And then earlier you were going to dive a little bit more into Chapter 7. You were going to bring up something about it. What was that you were going to bring up?
It's a great question. So after, the process is so you file a bankruptcy, you have to file your petitions, you disclose all your assets in a bankruptcy petition schedules. Then there's something called a 341A meeting of creditors. All the numbers in bankruptcy pertain to the statute that's written. It's very annoying, but that's what it is. And that's a meeting of creditors where the trustee kind of verifies certain information. They've looked at your petition and, have questions. You're supposed to submit a lot of financials to the trustee. This is why you got to do your homework first.
Yeah.
And then it opens it up to any creditors for a few minutes to ask questions effectively under oath about it. And that's kind of a way to check the trustee to see, if the debtor's being honest. Trustee doesn't have unlimited resources. They have a volume of cases. If it's not obviously wrong on the face, if they provided the financials, they look okay. If there isn't a creditor raising their hand, standing up, saying no, I know where the bodies are buried. I know they have an account here that they're not disclosing. Then it usually rides through. So it is like everything else, an adversarial process, right? You have to have people on both sides kind of duking it out a little bit and being honest to kind of get to the truth, get to the honest answer.
Yeah, and you made a comment where you were saying that they open it up for a minute to creditors to come in and like make claims to see if they're being honest. What exactly does that mean? Does that mean like the trustee is then reaching out to each creditor separately or sending them letters and being like, hey, are you actually owed this amount? What can you show?
Or no, I wish it was like that. No, so the trustees don't get paid enough, right?
Yeah.
So they get paid, I think, $60 or $90. I'm blanking. Per case as a flat fee. It's nothing. And then they get a percentage of what they can marshal and sell, right?
Got it.
So they're doing a lot of work, and the cases just come to them randomly. There's like a wheel, right? So if 100 cases get filed today, they just get randomly distributed.
What do you mean by marshal and sell? What does that mean? Like,
so their goal is to try to collect or figure out where all the assets are and figure out whether they can sell them to liquidate to cash to pay unsecured creditors. So that's their goal. So the 341A.
Can you give some examples? Sorry.
Yeah.
Of what are some assets that they would marshal and sell?
Yeah. So some could be like, money in a bank account. And then we're excluding all the exemptions of what you can protect, right? But there's money in a bank account. You have a house with equity that you can't protect. Usually they look at that in California. That's kind of the big one they look at.
Yeah.
You got a boat. You got maybe extra cars that are paid off, right?
Okay.
And you can sell things like that you can, maybe a life insurance policy or something like that.
Okay.
So it just depends on.
Like large monetary assets is what it sounds like, but they're not just coming into my house and like being like, oh, this painting is worth that,
Correct.
Unless they knew it was a big painting and maybe it's something that was publicized, right?
Yeah.
But realistically, it's more just like whatever your big things that you owe money on or that you own and they have records of.
Yeah, the trustee doesn't do it. This is not like have you watched like the OJ documentary on Netflix, or not the documentary but the 10-part series where they kind of walk through his house?
Yeah,
and
they go through the house. Yeah,
you don't do any of that.
Okay, got it. That's what I'm envisioning. Is
Yeah.
somebody coming to my house, being like, oh, okay, well that looks like it has value. Okay, that has value.
They don't do any of that.
Got it. So it's just like whatever your big things are, like home, your bank accounts, and probably whatever there's like public records about.
Right. So when you're the debtor submitting these documents and these petitions, a very long form, right?
Yeah.
Many pages. You're disclosing everything. You do it under oath.
Yeah.
So they're taking you at your word that that you have this painting, you're valuing it correctly. You have this car, that's what they're looking at.
Yeah. If you lied, can you potentially face jail time if you hid some things?
That's another good. These are great questions. So usually lying, if it can't be corrected, will or if it depends on the severity of it. Usually the remedy is they'll dismiss your case, or they'll deny you a discharge.
Got it. So you don't want to lie because you want the bankruptcy.
You
so
want
it's
the
not
you want
worth
the
you
protection.
hiding the thing. If you're hiding the thing, it means you can probably afford to pay it.
Now, if the lie, and depending on what it is very bad, the trustee can make a referral to the Department of Justice, the U.S. Trustee, to do an investigation for a criminal referral.
Okay.
But that's not handled by anyone other than the Department of Justice.
Yeah, that's a completely separate thing.
The trustees make referrals all the time, and the U.S. Trustee's office investigates and does what they need to. No one else has control over that. That's their job, and that's what they do. You read about it in the papers. It's pretty egregious stuff that results in it. Usually lying or stealing money is pretty bad lies that result in money being stolen.
Gotcha.
Yeah.
Okay, yeah, so earlier, sorry for cutting you off so many
No.
times. I appreciate you answering my little side questions.
It's the way to do it, because bankruptcy is just a cascade of definitions. Yeah.
Got it. And so the trustee is collecting all this stuff, and they're basically showing what your assets are and what can be used to pay off the debts. And then after they do this full collection and you've submitted this report, what are the next steps?
Yeah. So they're not taking anything yet, right? So you have a petition that says, I have a house, I have a couple cars, I have clothes, paintings, all that. It's just there. The trustee doesn't touch any of that.
Yeah.
Once it's valued and all that, they can decide whether it makes, after exemptions and so forth, whether they can sell anything.
Yeah.
If not, they're done. Like as long as the debtor complies with their responsibilities, take certain courses, disclose. The trustee will say, I've administered the estate, I'm not making any distributions, and I'm done. Then it's up to creditors, to the extent you have any that really don't like you, to then say, oh no, you've lied on your petition, you have done certain bad acts. I'm going to either do one or two things by a date certain, which is object to your discharge, which is litigation in bankruptcy court, or say my particular debt, not everyone else's, mine, should be non-dischargeable, meaning it should survive your bankruptcy case. Yes, you can get rid of all your personal liability from everyone else, but my debt stays forever until you pay it off. And so that's a whole process. And usually we can talk about different situations that arises from.
Yeah, so it sounds like they can discharge some debts, but not all of them, based on specific circumstances. I guess what would be like just one example of like why they would discharge every other debt, but not that specific debt?
Yeah. So generally speaking, the discharge applies to your personal liability, and so not your real property, right? So your property rights, they call it in rem. Those are unaffected. So your personal obligations can be. Then there's a list of exceptions in the code of what it doesn't apply to, and it's the stuff you would think about, right? Certain types of taxes, depending on when they are, child support, alimony. You can't get rid of any of that.
Can't get rid of that. Yeah,
right?
that's that's a very real thing in personal injury cases too. Whenever there's a child support lien on a case, we have to pay the child support lien before we pay the person for their settlement. So if they owe more in child support than their settlement, they're getting $0, and that's just kind of how it works.
And that's real, right? Because there's other people who have to get paid first. And so HOA dues that are due after a certain point. There's a list of those things. I mean, it gets complicated too. Criminal restitution, securities law violation, stuff that most people don't deal with, right? The main ones that people deal with tend to be taxes, kind of maybe post-bankruptcy HOA dues, maybe DUI type judgments are non-dischargeable.
Okay.
And then the main one, which is where a lot of litigation happens, are under like 3 different buckets. And so the other one you can't discharge, student loans is the other big one. You technically can under a hardship discharge, but it's in our area, it's nearly impossible.
Completely different process.
It's pretty much so that'll take some congressional rule change for that to happen, especially out here in the Ninth Circuit. The ones that I deal with on the creditor side, for example, tend to fall in 3 different buckets, and those ones actually require you to file litigation in the bankruptcy court to prove that you're entitled to it. The other ones are automatic if you can just show it, like it doesn't require litigation.
Okay.
Like the child support one, right? You show the child support order, you're good.
Yeah, sure.
You don't have to litigate that. It's good. The ones that require future litigation would be fraud, right? Requires you to prove that, say, like you got a state court judgment, right? Let's say someone sues you for breach of contract and for fraud. You owe them $100,000. You're aggressively enforcing it, so they file a bankruptcy, right? That's not automatically non-dischargeable. If you don't protect your rights in bankruptcy as a creditor, the debtor will get rid of that with a discharge. So what you have to do is you have to file litigation, say, no debtor, my debt, this fraud judgment is non-dischargeable because it fits with the elements of fraud. And depending on what you've done in state court, you have to effectively relitigate your case again if you don't have the correct findings. The other one is kind of like embezzlement, breach of fiduciary duty. And then the third bucket is like willful malicious injuries. So like intentional type torts tend to fall in that bucket. Bad discrimination cases, they can fit in that bucket. If it's just a standard breach of contract case, it will get discharged in bankruptcy.
Got it. Okay, so it sounds like, based on what you're saying, that there is a hierarchy of different debts that, based on what they are and the circumstances, that are not dischargeable. And I guess just, for your knowledge, is this hierarchy listed out anywhere? Is it something that people can easily read, or is it something that you've just learned through experience of handling this many matters?
Yeah, so everything in the bankruptcy is a section in the bankruptcy code. And so we call it bankruptcy code. If you really want to look it up, if you Google bankruptcy code, it'll come up. But you say bankruptcy code, the exceptions are under 523A. And it's just a laundry list of exceptions.
Got it. But what I'm saying is, like, in that laundry list of exceptions, is there a hierarchy of ones that are like take precedent over other ones?
No. So those, they apply to your particular circumstance as a creditor. There's no hierarchy. The hierarchy comes from who gets paid in what order. The waterfall of payments. That's where the hierarchy comes from.
Okay, got it. But it's not so much that there are certain debts that are non-dischargeable based on what they are. Just literally fact by fact by fact.
Yeah. So right. So it's by the debt, right? So your marital, if you owe child support, that's not higher, at least in terms of non-dischargeable. No, it's all it's like horizontal, it's across the board.
Got it.
As long as you prove it's non-dischargeable as to that particular creditor.
Got it. So unless there's an exception, that's basically where it comes into play. Okay. And then really where it comes into importance using the code is the hierarchy of who gets paid first. So when we're looking at like the hierarchy of who gets paid first, what are some things that would be like at the top of the list, and what are some things that would be at the bottom of the list?
Right. So the top of the list, so the minute you file, whole slew of things come into effect with the bankruptcy. So that's why you don't file for the sake of filing, because you're imposing a lot of court and creditor scrutiny on yourself.
Yeah.
But the hierarchy of payments, secured creditors are at the top, but they have collateral, right? So they get their payments through, if it's the lender on your home, your house is their collateral, so they're put to the side. Then, naturally the government gets paid. Then at the same level, like with attorneys, for the debtor or for the trustee and so forth, they call them administrative claims. And then then there's a bucket of the stuff that I was talking about before, the unsecured creditors. That's where a lot of the waterfall comes from of the hierarchy. And so, for example, your child support payment, if there's a limited pool of money to pay people, like that child support is at the top of the list, right?
Yeah.
Taxes, stuff like that. The bottom of the list is just like your run-of-the-mill breach of contract, like you loaned someone money and they did it. Like that's at the bottom. The lowest category is equity. So an individual, it's irrelevant. For a company, the equity owners are always last. They only get paid after everyone else gets paid in front of them.
Got it. Okay. So this part of the process would come later on down the road after the filing, after there's already been a look at all the assets, and now we're determining with what assets we do have left, what can be paid, if any can be paid, but if not, otherwise, if everything is discharged, obviously they're not paying anything, but if there is assets to pay things, then there is a hierarchy that it needs to follow.
Right. And depending on what chapter, if it's overly complicated, it depends on what chapter you file and how the payments work. So like in a 7, if there are assets, the trustee will send a notice to the creditors on your list saying, hey, we think we're going to make a payment to you. So please submit your claims.
Yeah.
It's on a form saying what you're owed and why by this date, or you won't get paid. And so you submit that. And in that process, you get 10 of these things, say, for example, and then they're categorized, this is maybe secured debt, unsecured debt. Then, there's a process to object to the claim, right? Maybe you said you're owed 100. You say you're owed $1 million, but it's really only 100,000.
Yeah.
So you try to work that out, or someone submits a false proof of claim, or there's just an error. So there's a process to weed those out. Once that's done, then you're right. Then there's this. Once you have a lay of who owes what, how much there is to distribute, then that process happens by the trustee. Right?
Okay. Awesome. Very cool. All right. And so this process of filing with the court, is this like a normal lawsuit, or is this a different court entirely? Is there a specific bankruptcy court that you go through, or what does that look like?
Yeah, I was joking with, I was on a panel earlier this morning. We were planning for it, and we were joking about this because political situation is such that, things are moving in the federal government. But yes, so there is a bankruptcy court. So technically, the bankruptcy court is a division of the district court, federal district court. Congress and district courts have said, once you get a case, we're referring it to bankruptcy courts. So there's specialized bankruptcy courts. Technically, Congress could get rid of bankruptcy courts and it would fall to the district courts.
Yeah.
If that happened, I assume the district courts would say, hey, state courts, you deal with this. We don't want to deal with this.
Yeah.
So there's always someone to do it. But the bankruptcy courts have become a specialized court because they are complicated and no one wants district courts dealing with criminal law. They don't want to deal with this stuff.
Yeah.
The state courts, of course, don't want to deal with it. They're already slammed with everything else they have to deal with because everything funnels to them by default.
Got it.
But you don't. So when you file, it's called a bankruptcy petition. You file a petition, it's listing all the assets, all the disclosures. That's what starts the case, and it's an electronic filing online.
Got it. For anybody who's looking to potentially go down the bankruptcy route, I know some people, because of Google, and they think they're Google lawyers, and they just think that they can figure everything out on their own with like AI and stuff. I guess, like being a personal injury attorney, right? I know that people can handle personal injury claims on their own, but like just from what I understand, they're usually getting, 1/5 or 1/3, let's say, in a good situation of what we would be able to get them. And I guess for people that do you think people are able to successfully fulfill a petition and do it without an attorney, or do you always recommend having an attorney?
I mean, it's going to sound self-serving, but I think you should have an attorney. Now, if you can't afford one, the bankruptcy courts have like free clinics. So you can look on their websites. They have certain times you can bring your stuff there, and people volunteer their time to help with that.
Yeah.
There's also like pro bono organizations, Public Law Center, PLC, and others that they have clinics too to help you file if you need it. I would never recommend doing it solo. I think you can't unring that bell for the most part, right?
Yeah.
Filing bankruptcy is not something that can cure everything. It can make your situation worse than if you didn't file, depending on your financial situation, what happened in the last few years that led to you wanting to file a bankruptcy. So with caution, you always have the right to file a bankruptcy,
Of
right?
course.
But you shouldn't necessarily exercise that prematurely.
Yeah. And I mean, when it comes to bankruptcy or just anything dealing with the court, I think just a caveat that I always tell people is, yeah, you could probably try to figure it out on your own, but you don't understand that there's such little intricacies that you could lose your entire case, or you could get it dismissed and you're not able to achieve your goal just because you didn't know about a rule or an exception.
Right.
So the amount of money that you think you're saving by not hiring a lawyer is going to be way more of a headache for you failing or getting your case dismissed or just it not succeeding. And the little money not the little money, but whatever the cost for the lawyer is, that would have been much wiser with your time and energy to put it to someone who's a specialist that can help you get it done properly and do it the right way.
Yeah. That being said, I mean, people file bankruptcies for a reason, right? They're struggling. And so there are a lot of, individuals who file on their own, pro per, pro se, how we call it. So bankruptcy courts are versed in that. I mean, I think 25%, maybe a third. There's a lot of pro per filing their own bankruptcies. Those tend not to succeed for the reasons you stated.
Yeah.
But I'm curious in your field with the personal injury. I mean, are they taken advantage of in the when they file their own? I know the courts are one thing, but or is it mostly handled before the litigation happens? Is it the pre-litigation workout that's where they kind of get screwed, for lack of a better term?
I mean, there's like 1,000 reasons why we're going to get them more money. Like it really comes down to, like, I could name some big ones. One is like going to the right doctors, treating with the right people. Like, first of all, in my opinion, anything through medical insurance is a fraud. And I think our medical insurance system is an absolute mess and it just screws people over. The bottom line is when you go through medical insurance, so if you're not extremely wealthy and you can't pay cash for your treatments, you are not going to get the full and proper treatment that you need. The normal medical insurance, when it's not done through a lien and done through doctors that specialize in personal injury, they're only going to do treatments that are medically necessary. So for example, on every personal injury case, one of the most important parts of the case is getting an MRI. You need an image of the soft tissue damage that is done to a person's spine. And without that, I can't point to that image and say, this is what's causing my client to be in pain. And if you go through medical insurance, they will not send you to go get an MRI if they send you to get an MRI for about 4 or 5 months when your body is already mostly healed. So you're not even going to be able to see what the real injury was in the full breadth of it. And secondly, they only send you for MRIs if you go through like 3 specialists, you beg and you plead, and then you basically force your doctor to write a recommendation for an MRI. When you go with a personal injury attorney, we work with doctors that immediately send our clients out for MRIs because they understand, one, you shouldn't really be treating someone unless you see what's going on in their spine, because you don't want to adjust them and you don't want to manipulate them unless you know what's really going on, the details. You don't want to pinch on a nerve or cause more damage. This is basic stuff, but because the medical insurance side of things is just so muddied and literally the insurance companies incentivize doctors to do less treatment because the more treatment they do, the more they have to pay out, right? So that's like a big thing, is just the doctors that we work with give our clients the golden treatment. They do what's best for them. At my firm, we do a really holistic approach. So we do things like, PRP injections, or we work with stem cells, and we do a lot of like acupuncture and massage, and we do the things that are really necessary to get people better. But when a person handles it on their own, what's going to happen is this. They're going to go to their doctor. Their doctor is going to say, great, here's some Norcos. Enjoy. You have a whiplash injury, and that's all that's going to be written on the records. They're going to have $500 in medical bills, and maybe they'll settle for like $2,000, $3,000. But with me, on like, let's say just a lower and personal injury case with not a lot of injuries, they're going to go to a chiropractor, they're going to get MRIs, they're going to get physical therapy, they're going to get massage, they're going to get acupuncture. We are going to heal them and actually do what's best for them, and not just give them a Norco to mask their pain and then let them be in pain for the rest of their life because they didn't do the proper treatment.
But you're also taking a snapshot right when the injury happened too, right?
Exactly.
Or when they come to you, obviously.
Yeah, because we're getting the MRIs within the first couple weeks of the injury, so we can see what the damage actually is. Like, there's just so many little things when it comes to medical treatment. So yes, you can handle it on your own. Not only are you going to be in pain for the rest of your life because you didn't get the proper medical treatment, you're going to get paid way less. And on top of that, you're going to have to deal with the headache of dealing with insurance companies that act like you're their best friend. But the truth is, Nationwide is not on your side. You are not in good hand with Allstate, and Mercury Insurance is probably descendant from devils. So, like, with that information, just there's a reason they record every single conversation. They want you to, mess up, not say that you're injured, or just like to fuddle over things because they want to box you into a hole and pay you as little as possible. Right. The first thing an insurance company does when they sign you or when you make a claim for an accident is the first thing they do is they look at your record and see how they can drop you as a client. That is their first thing that they are told to do in the insurance company. How can we drop them as a client? Did they not pay on time once? Did we send them a letter and they didn't respond? They try to find any little exception or weird way to get you out and to screw you over. So, like, I just don't think that the system is set up correctly, and a lot of the premise from these big insurance companies need to be changed, medical and the car insurance side, property and casualty. But there's so many reasons. So I hope that kind of give you a little bit insight.
No, it is. And it shows the compassionate side of your practice that I assume you guys, fronting that cost for the clients to help them with that. So.
Yeah. We work with doctors mostly on liens. So even the doctors that we work with, they don't take payment until the end of the case. So it's like there's so many benefits as to why you should work with a personal injury attorney for an accident, because you're not paying for the medical treatment. You don't pay for the legal service. Of course, you're paying for them at the end of the case, but you don't have to pay anything up front. Medical treatments can cost thousands, tens of thousands. Like, I've had clients where they have surgeries and it's, $400,000 or $500,000 in medical bills, but they paid $0 out of pocket, and then they get a check at the end. So it's really a lot of things that help them out. So, I mean, I know I kind of went on a tangent.
Yeah, that was on me, but you also triggered, and I forgot to say that a lot of reason why people file bankruptcy is medical debt as well. Yeah. And so they can discharge that.
Yeah. So, I mean, it sounds like when it comes to any type of law, and when people even call me and like, when they're like, should I go with a public defender? I'm like, I don't know. Do you want the worst case scenario? It's just like, the money that you're going to spend on a lawyer is always going to get you a better result, even though you might not feel like it's going to. And it's always also just going to give you peace of mind. And for me, in my life, I will always pay for peace of mind. And that's worth an invaluable amount of money to me. But of course, not everyone is wired the same way, and not everyone feels the same way. And some people would rather be stressed out and save $5. And I just, that's a hard thing for me to understand, because I always want to do the thing that's going to be the best emotionally for me, and I will always figure out how to make more money.
Yeah. Well, and AI hasn't replaced us yet, so I don't think the device is good enough yet to replace us.
Yeah.
We'll do this again in a few years and see.
We'll do this again in a few years and have a conversation. I think, like, that's the thing is, like, when it comes to attorneys, it's like us properly advocating, because I had a long discussion with somebody at a Tony Robbins conference about whether attorneys are going to get replaced by AI, right? And the truth of the matter is, as long as we're going before a judge, I would think that what would have to happen for attorneys to be replaced is you'd have to get rid of judges, right? And you'd have to decide that a computer is more intelligent than a human being to decide what the law is. And I think the law is meant to be interpreted, and there's just so many specific things and emotions that come into play, and specific facts, right, that really play to each situation. And if we depended on a computer to do it, I think it would be so cut and dry, and it would really remove the emotional aspect. So I think attorneys will always have jobs. There might be some aspects of our jobs that will be taken away, like maybe filling out the form, right? Somebody might be able to just press one button and that whole form is filled out with all their assets, because maybe it's collected in one place. So things will get easier, and so I think lawyers will just be dependent more on using the law, using their brain, and advocating or negotiating, which is really where our specialties come in, and also dealing with juries, where that's something I don't see us getting rid of. So I've definitely had this conversation.
I'm with you. I was thinking that you can always represent yourself, and so that's the problem if you're powered with AI. But I think what AI can't get rid of is the human connection.
Yeah.
So working things out with the client, working things out with opposing counsel, and so forth. I think you can't really get rid of that.
Yeah.
And that usually is where kind of the magic happens anyways, right? That's how deals are done, is the in-person communications, in-person contacts, the mediations, just humanizing it amongst each other to be like, okay, this person isn't the devil reincarnated, right?
No, for
that
sure.
person is in an a-hole or something like that.
Yeah, not only that, but I think like too with like AI in general, it's like about the questions that you ask, right? If you don't know to ask a specific question based on a specific exemption, the AI is not most likely going to just spit it out.
Yeah.
And so like if you don't know that based on your experience, and that's why like, when people ask why are the most expensive attorneys so expensive, it's like you're paying for experience. That amount of money that you're paying more is going to save you more on the other end, or make you more on the other end based on their experience. And sure, you can argue that maybe AI AI will be able to see all possible scenarios, but it's also not going to be sitting there advocating for you. And in a courtroom, you have to ask the questions. You then have to learn from the AI, and then you have to go do it yourself, which is a completely different ballgame in itself, because I highly doubt that I see a situation where we're going to be allowing robots to go in and represent human beings in the courtroom. I think that would, if that does happen, maybe 10, 50 years would be like the range of where those conversations would happen, but I don't see it happening in the near future.
Yeah. It's one of those things where if like you watch a legal show on TV, right, and you know the law on that, you're like, they get things wrong all the time, but you only know that because you know the law. So I feel like it's the same thing. It's hard to discern and figure out what's correct and not. I mean, by first approximation, that answer seems okay, but if you don't have the expertise, it's a little more difficult to realize, oh, that's actually quite wrong for 1, 2, 3, 4 reasons.
Yeah, 100%.
I'm with you.
Yeah, and I know we kind of got in the weeds here, but I wanted to bring it back because I wanted to talk about. So I want to kind of finish up like personal bankruptcy. So in regards to personal bankruptcy, are there like any like horror stories or some main things that you've seen like gone wrong, things that people should really look out for, and then after that, I would like to definitely jump into business bankruptcy and talk about that.
Yeah, I guess so. We didn't really talk about so the two main personal ones. So there's 3. So there's Chapter 7, we talked about liquidation. So Chapter 11 is technically a reorganization. An individual can file that too.
Yeah.
Everyone can do an 11 but they are the most expensive, so we can put that to the side. The other main one that Congress actually wants you to do more of is Chapter 13s. Okay. And that's kind of like as long as you have net monthly income, that's kind of what they want you to do. It's kind of a court order payment plan, and you get this. That is the benefit because you get the easy in, easy out. I mean, you can file and you can dismiss. You have an absolute right to dismiss it. There are consequences to that, of course, but you can file it to protect your home. It gives you the breathing space. Chapter 13s are very flexible. What you end up doing is...
And you were talking about Chapter 7 before, right?
Right, before we were just talking about 7s.
Okay, got it.
So I've got to be clear about that because it's very different. So there is, for example, you file Chapter 13. There's a complicated formula about your income and expenses and how much disposable income you have.
And Chapter 13 is also personal, or is this business?
Correct. So good question. So 7, anyone can file. Well, a company or an individual can file. An 11, a company or individual can file. And a 13, only a human can file, only an individual. It's not for a company.
Okay. And what is the difference between a Chapter 7 and a Chapter 13 bankruptcy?
Perfect. So 7 is the liquidation that we talked about. Yeah. A 13 is a structured payment plan. So if you have $100,000 of unsecured debt and you meet all other requirements, you qualify for the debt limitations and so forth. Because there are we never talked about what requirements you have to satisfy to become, to be able to file a 7 or 13. We could put that to the side because you'll need a bankruptcy attorney for that. It's just some of it's nuanced, but for a 13, it comes down to your disposable income and how much you can pay. So if you have $100,000 in total debt over, say, you owe 10 people, and your disposable income is $1,000 a month, or say it's $200 a month. If your plan's approved, you pay that $200 a month for 5 years to the trustee. You pay the trustee every month $200. The trustee disperses it to pro rata to your creditors. During that 5-year period, the stay is still in effect, so they can't harass you. You can't do that. The minute you're done paying after 5 years, which is difficult, but at $200, let's do quick math, but let's say that's like an 8% plan, right? So you're paying 8% of your debt. You get your discharge. Now there's more nuances to that, but that's effectively what it's a court structured payment plan. 13s are great if you can do it.
So wait, so you don't have to pay the full debt. You can just pay a portion of it?
It's a complicated formula of what your income is and what your expenses are, and you have to have a certain amount of disposable income. So you pay that. So what you live, what you live on, you need to have.
You pay what you can afford instead of not paying anything.
That's a great way to do it. Yes, a great way to simplify it, as long as it meets certain exceptions and so forth. Correct.
Yeah, I understand it's very fact specific, but that also sounds great.
Yeah.
It sounds like somebody taking full accountability of their life and not just saying fuck you, for lack of a better term, to the person that they owe, the creditor, right?
Yeah.
So the person they owe the debt. So they're like, okay, I make this much money. I can afford to pay a little bit, but realistically, if I keep paying the full amount, I'm going to drown and I'm going to be done. So I'm able to pay this portion. Instead of paying you nothing, I'm willing to work and pay this amount. And as long as you stick to it, then it discharges the rest of the debt. So let's say you agree that you can pay 50% of it. The other 50% is discharged after 5 years.
Yeah, as long as you complete the plan. I mean, there are caveats to
whatever the plan is, not 5 years saying that's the plan.
No, it's a 3 or 5 year plan.
It's a 3 or 5 year plan.
Right.
Okay.
For the most part, it's 5 years. So let's just say it's 5 years. That's right. Now, there are other complications to that in the sense that, like, let's say you get a tax refund during that time. Well, that should go in to pay your creditor, so they get a higher distribution. So you
Do you have to report that?
should report it.
You should. Yeah. I mean,
Yeah.
that's the better question. Should you report it? Yes.
So the answer is you're obligated to.
Yeah.
If you don't, and then the trustee or someone finds out, they can modify your plan for you.
Okay.
It can cause trouble for you. Let's say you don't
Yeah.
have it anymore.
Yeah.
Then maybe you made 2 years of payments.
Yeah.
If it blows up after that, then it's like you never filed.
Yeah.
So 5 years is a tough time. I mean,
Yeah.
the reason people file is for various reasons. One is because they're not necessarily very good at finances. So you have to have better financial planning and management of your finances going forward too, right? It's not just, hey, I got rid of the debt, I'm scot-free. Like, you have to change behaviors, right? Save more, spend less, put money for retirement, be responsible with what you spend your money on and so forth.
Yeah. Okay. So it sounds like also somebody might try to go down the Chapter 7 route, and then they'll realize that they actually only qualify for the 13, right? Or would a trustee maybe tell them that? Or, you know what I mean? Because it sounds like people might try to discharge everything, but then the trustee might look at everything and be like, no, you can afford to make some payments, and then maybe Chapter 13 would be an option, and if they get denied for Chapter 7?
Yeah, so those are complicated questions. So let's start with the 13. So 13 is easy in, easy out. You have an absolute right to dismiss your case in a 13. In a 7, this is what I was saying, you have to plan. If you file the wrong one, not necessarily. You can't get out of a 7 on your own. The court can dismiss it. You can file a motion to convert your case to a different chapter. But there's a formula for that. There's a test for that. And so you may not qualify for that. But a 13, if you said, oops, you can convert it yourself or dismiss it yourself. There are consequences, but that's the way to go usually. If you qualify for a 13 based on your debt limits, right? If you're a high debt person, these rules changed recently because Congress didn't get its act together. But the eligibility is 2 buckets. It's 500 and change of unsecured debt max and 1.5 million of secured debt. So if you have a very expensive home, it doesn't. California, that affects us because we have high real estate prices. If you're in other states with where real estate isn't that high, it's hard to meet those debt requirements. Okay. But as long as that's the eligibility for that. And for a 7, it's your income, and it's based on a formula. If you're a single person household, second. There's a presumption of bad faith or not. So that's the complication to overly do it. But
so in 13, you're saying you have to have a certain amount of debt to even qualify.
Under a certain amount of debt.
Under a certain amount of debt. Okay. Mm-hmm. Understood. Okay. And
in 11, you can always funnel into an 11. The irony of an 11, a reorganization for an individual company, is bankruptcy is an expensive process. So usually it's for people who have money. Seems like an oxymoron, but it's the truth. So
got it. So you're going to explain what Chapter 11
Sure.
is.
Yeah, let's get into that. Yeah. So usually you see an 11, and what you're seeing in the country right now are mostly 11s, right? This company's reorganizing. Chapter 11s are reorganizations.
Is it a business? So this is a business one.
This could be a business. So 11 can be an individual too. That's what's confusing. But
okay.
But you're right. So 11s, generally speaking, when you hear about them, are corporate reorganizations.
Okay.
So what you're trying to do is say, effectively, it's like the 13, but in an 11, obviously more complicated and expensive. But you're effectively trying to figure out what your assets are. You're figuring out what your debts are. You're figuring out what your operating income are, and you're trying to figure out what you can pay over time and how you can come out of bankruptcy as a restructured organization. And it's similarly 3, 4, 5 year plan. It can be extended depending on different factors.
Okay.
11's very complicated and very expensive, but it is something that is available to everyone.
Okay, so let me clarify. So I thought, I guess I didn't know. So business bankruptcies, is there different numbers for them, or you're saying that Chapter 7, 11, and 13 can be used interchangeably for individuals or businesses, or it sounds like Chapter 7 and Chapter 13 are individuals only, and then 11 could be an individual or a business?
Great questions, and let's start over. I wish I had a Katie Porter whiteboard.
Yeah.
So a 7 can be both.
It can
individual,
be both.
and corporate. You will almost never see a corporate 7 because we can go into details or offline, but it's they're so rare because it invites scrutiny, a lot of scrutiny into the officers. A lot of people refuse to file corporate 7s because it's almost like malpractice.
Got it. So they don't want to file for Chapter 7 because the trustee would get too deep of a look into the business, and it would almost show that there was something that they did wrong or something that's improper, and it would basically open them up to potential lawsuits.
Yes, that's a good way of putting it. So it's several reasons. One, in a Chapter 7, well, let's go back to your other question. I'll get into that because I keep digressing. So 7 is both, an 11 is both, a 13 is only an individual.
Okay.
For a 7, for a corporate, there's many reasons why you wouldn't file a corporate 7. One, you don't get a discharge. So it's like, what's the benefit of this? A corporate,
you don't get a discharge for
a company.
corporate?
There's no company corporate. It's only for individuals.
Okay.
So there's no corporate discharge in a 7. Second, they look, for fraudulent transfers, they look 4 years back. If you're an insider, so say you're an officer, they look 1 year back from when you filed. Maybe you made a distribution to yourself and all that. All that can be clawed back. And so what you're inviting is you're getting no benefit here, and you're inviting kind of scrutiny into the finances so that it hurts the owners, right? That's fine. I mean, you can do it, but the owners are separate from the companies, even if they don't think they are. And so that's what ends up happening. Also, I mean, so why do people file a corporate 7? It's very limited reasons. One, maybe to tell the world, like, I'm doing a public burial, like, leave us alone. Maybe you have a ton of lawsuits and you have nothing to hide. The owners only put money into the company for the last 4 years and they weren't taking anything out. Everything else is clean. It's just an unfortunate company that's gone under. Yeah, maybe that but those are like the limited circumstances to do that. Okay. Otherwise, otherwise you go into.
What were those limited circumstances one more time?
Sure. So public burial. So you want to tell the world, like, hey, we're done. We don't have anything. Yeah. Okay. And that's, of course, with a lot of planning beforehand, the usual caveats.
Okay.
The other is, like, say you're getting sued, 10 lawsuits against you for whatever.
Yeah.
It's effectively the same thing saying, hey, we're stop filing the bankruptcy. Does provide an automatic stay to lawsuits temporarily. And you're saying, hey, I got nothing to hide here. We don't have any money. So if you want to spend money to get a default against us, be my guest.
But we're just admitting we got nothing.
Yeah. Submit a claim in our case. We got nothing.
Okay, cool.
Yeah. Very limited circumstances.
Yeah.
And even then, maybe there are other options and other things to work out.
And so you're saying I guess what it's leading to, from my understanding, it sounds like bankruptcy can just allow somebody to kind of restart. And then it sounds like in situations where the company is dead and they just want to stop, they would do a 7. But if they maybe want to restructure and just disclaim some debts, they would do a 11, and then they can continue moving forward. Does that sound about right?
Yeah. So an 11 is the way to go if you want to restructure, right? You can do other things in 11. Let's not overly complicate, but that's what you want to restructure.
Got it.
A corporate 7, I would even argue you did a good summary, and even then I'd say probably not do it. Just. Can dissolve if you qualify, or just let it go, or just file a return, keep it open for a few years. There are other legitimate ways to handle that, where inviting the public scrutiny and a public finding of 7 is usually not worth it.
Got it.
Yeah.
Okay. Super interesting. Okay. And then for when it comes to dealing with a Chapter 7 or Chapter 11 for a business, what are some scenarios that you're seeing this just occur? When do people start going down the road of being like, I think I need to file for bankruptcy in my business?
In 11, it's usually something like they have a bunch of business loans. Things are becoming due. They can't afford to pay it, right? So they're trying to work things out with the lender beforehand. It doesn't work. And so they can come into bankruptcy and you can try to, effectively kind of restructure that loan, right? Pay a certain amount here, get a lower interest rate, pay them over time. Maybe some owners or other people are going to put cash infusion. Mm-hmm. The other reason is people want to sell the valuable assets, right? Without having a bunch of people at the door saying, pounding on doors, I'm going to liquidate this asset, I'm going to sell this, I'm going to force a judgment. Bankruptcy is a good way to sell assets free and clear, meaning if you're someone who wants to purchase a good asset that this company had that's filed bankruptcy, having a court order saying, if you bought that asset through the bankruptcy process, having that court order saying you got it free and clear is like the best. There's nothing better than that, right? You don't have to worry about success, other liability. You have a bankruptcy court order blessing that purchase.
Can you give an example?
Yes. So sometimes, let's say a company's going out of business, like a wine company or something, right? They may want to sell their inventory. They may want to sell their IP. They may want to sell their website. Those can be valuable assets because of a customer list or something like that, for example. You can do a court-ordered bankruptcy sale process for that. Someone could come in and buy it, and we're buying it free and clear. Now, it's actually subject to auctions and to get the highest value possible.
Yeah.
But it's it's a very orderly process.
Is there a website or a place where you could potentially go see people selling their assets or their bankruptcy assets to try to make some money? If I'm maybe I want to find some stuff for cheap, or somebody's selling some things that I find of value, or is it I have to know this wine company, know that they're going through a bankruptcy, and then they offer it to me?
Those are great questions. I maybe this is my ignorance, but I don't know of any centralized database. I wish there was, but usually it's insiders who know, people in the industry know that this one's filing, and there's some valuable assets here you can get on the cheap type of thing. The ones that you know about are outside of bankruptcy, like tax sales and other things of property that the counties put up. That has a centralized thing, right? You can probably go on, for selling of homes, I think there's, trustees have the website of what ones are going for auction.
Yeah.
Those ones are public. But a company, you have to scour. I mean, there are web databases you can scour every day. You can say this company filed a bankruptcy. You can have a list of them. They're not a crazy amount across the country, right?
Yeah.
And then you can monitor those cases and look into them. So it's kind of, you have to do some legwork on that or be an insider.
Got it. So it sounds like you really have to know somebody. It's
Yeah.
not just like there's some place that you can go. Because when you say like an auction, I just figure there might be like a place like how they have vehicle auctions where they go and just do them regularly, but it doesn't sound like that.
No. Like real estate's like that for the trustee. None of that. For companies, it's all public record, but, you got to pay to search and know what you're searching for.
Okay. Got it. And then in regards to like business bankruptcies, when you see people coming to you, what are some like the biggest mistakes that you see people make throughout the process?
Yeah, I think this will be maybe generalized across the board. So a lot of times you see
Individual or business.
Yeah, so for everything you need, business especially, you need clean financials, right? You got to clean up your records, good P&I, good balance sheet, profit and loss statements. Have an accountant in place or bookkeeper. You got to really have, because you have to know what's going on.
Yeah.
Individuals, I think the problem tends to be they think they're just not organized, right? They don't have all the documents that the trustee is going to ask you for.
Yeah.
A year of bank statements, it's probably 2 years of bank statements, 2 years, your last 2 tax returns, title report, all the stuff that they want to make sure that what you put in that petition, at least facially, is accurate if they look at the financials. So you see a lot of that. I think people make mistakes by either filing too soon without correct representation or help, or not filing in time, thinking it's going to hurt my credit or something like that.
Yeah.
And the credit's a big thing, but when we can talk about that, there's stuff like that. So bankruptcy is a lot of it. It's about planning and timing, and so you really need to have a clean financial record and clean financial picture of what's going on to understand what are your best options.
And what do you mean by timing?
Yeah. So for if there's certain taxes you want to discharge, but they're just maybe you're at the 1 year, 8-month period, but you can get rid of it if it's 2 years plus. You might want to wait that 4 months if you can, right, to discharge if you're qualified. If you're someone who's maybe received a preference, within 90 days of filing a bankruptcy, if you preferred a creditor over another one, you have to return that money. For an insider, like a family member, for your company, it's the officer or CEO or something like that. It's a 1 year look back. You may want to wait that 1 year, 1 month. There's nothing wrong with that. That's just sound planning, right? If you can, so that those things don't get clawed back. There's planning that way.
You're saying like strategies to essentially help you to save yourself from the most headache when it comes to either paying a higher amount of debt or having to reimburse people or just basically to discharge some assets.
Yeah, and then not to invite a lawsuit in a bankruptcy case if you can avoid it.
Yeah, of course. Not to commit fraud, I guess, for lack of a better term, where you're trying to hide things, but just there's going to be decisions that will be wiser if you just wait a certain time limit or you do things in a specific way. So, of course, that just comes down to working with the right, bankruptcy attorney to make sure that you are doing the things that are going to be the best for you in the long term and going to save you the most money at the end of the day.
Right.
Yeah. Okay. Very cool. And then you said that when it comes to like individual and business bankruptcies, they're very similar in the sense that it's the same type of planning and it's the same type of things that we're really looking for. Is there like anybody, or is there any specific advice that you'd give people in regards to someone that might be looking to start this process?
Yeah. So the considerations for an individual and a company are different. I think the process of having clean financials, people in place, knowing what's going on is the same. But a business is a moving beast, right? You got payroll, you got other things going on. You got to really plan for a business. So A, clean financials, B, have a good bookkeeper, have a good tax attorney. And then the process for a complicated Chapter 11 business reorganization, it's months. You don't just file it tomorrow. It's it's months in advance. And I'm just assuming a normal one. We don't get into other complicated versions of this, but it takes months to plan. And the reason is because there's a lot of oversight. There's a lot of disclosure. Everything's about disclosure in bankruptcy across the board. And so you have monthly reporting requirements. You need to have people in place that know the financials, that can make the reports, that can report correctly. And you have to have decent amount of attorneys, right, to be able to get the filings done, to do the scrutiny. All that. It's just that's why Chapter 11s are expensive. Is that there's just a lot of administrative burden, including paying your professionals to get this over the finish line.
Got it. Okay. So when it comes to filing bankruptcy, what are some of the negative effects of filing a bankruptcy, right? Because I guess in my world, I look at it as like, as an individual, I know it affects your credit score and it has negative effects, and supposedly you can't like get new credit cards, right? And I don't know what the exact details are, but also too, like looking at it on the business side, and we'll take it one piece at a time. I know like on the business side, you know, you hear of people like, let's just use an example like Donald Trump. He's filed for bankruptcy how many times, right? And he's discharged these debts. But really, at the end of the day, it sounds like it might have strategically been the right thing and probably helped save him a bunch of money. So let's start with the first question, which is, what are the negative effects of filing for a individual bankruptcy?
Yeah. So, I mean, it might not work. Usually you have a bad credit score. Okay. So it might not work if you've committed some type of fraud, maybe you have your friend put a lien on your house to protect it, or you do something like that. That can be bad for you. Maybe you transfer money out of the country, or you transfer money to a friend, or do stuff. Those are bad reasons to file. It's not because the bankruptcy is bad. It's because the conduct that occurred prior to it is bad.
Okay.
For credit purposes, I mean, if you tend to have bad credit because, credit is credit worthiness, right? Your ability to repay the debt, right?
Yeah.
And if you file a bankruptcy, the irony is it actually starts going up from that point on, right? Yes, there's a stigma. There can be cultural stigmas to bankruptcy and all that, of course, right? There's the personal human component, which bankruptcy does not solve, right? It's just the economics. Putting that to the side, I mean, if you get it, the minute you file bankruptcy, yes, it goes on your credit report. 10 years, I think about. But if you get that discharge, and depending on what you file, when you get it, I mean, your credit score starts going up after that. The minute you get your discharge, it goes up considerably. And so the goal after that is effectively, and the reason is because your debt ratio is going down, right?
Yeah.
You're eliminating the debt. And so my recommendation for that is, yes, do that. Yes, monitor your credit reports after that, right? That's always a good thing because they tend to be wrong. You want to make sure they're reporting it correctly. You can do that for free every few months on your own. You could dispute it on your own. If that doesn't work, you have to hire special consumer attorneys who can go after them for that. And you probably want to start establishing credit again, right? So open a credit card or two after, if you're allowed to, and start reestablishing your credit. I mean,
I've heard that you're not allowed to open credit cards for many years after you do a bankruptcy. Is that not true?
After you get your discharge and you're out of bankruptcy, yeah. I mean, they're not trying to bury you. You're trying to get credit again. They may have canceled your credit card, depending on what bank you're with.
Got it. So you probably have to go somewhere else
Yeah.
to see if they'll qualify you for it. But realistically, you're not going to be able to go back to the same bank because they're going to be like, you obviously just, discharge our debt.
Right. And I'm not trying to cast aspersions on any bank, but some are better than others.
For sure.
But the key is, you're gonna get a favorable credit card. Of course not.
Yeah.
But you're reestablishing your credit, and you'll see after a few years, and it's not very long. I mean, it goes up pretty considerably. For a loan for a lender, I mean, they have different underwriting requirements, but 2 or 3 years, I mean, it can recover pretty well.
Yeah, I mean, people want you to be in debt, right? And there's always going to be vehicles for where they're making money, because even for some of these people, let's say that you've been paying this debt for a couple of years, they probably have already made 2-3 times the money on you, right?
Yeah.
And so getting you back in that cycle, if you're somebody that repeats cycles, they're like, well, it's okay, we'll make money on them again. Yeah, I mean, like, I guess just like listening to this, if I was a creditor, is it just like I'm screwed? That's it. If the bankruptcy court approves and the debt is gone, there's nothing I can do and it's just forever disappeared?
No. So actually, I do a lot of creditor work. It's a mixed practice. You're not screwed, but it's harder these days with the California is a real estate based state, right? Assets, most of people's net worth is in their home.
Yeah.
And in the last few years, the homestead has gone up considerably. That's good for homeowners. It's bad for creditors.
Yeah.
But you're not completely screwed, but it's hard. They made collection harder for creditors, and that's fair. I mean, that's the gambit. That's the not the gambit. That's your constitutional right to file a bankruptcy, and as long as you follow the rules, you're honest, you disclose everything, you get the discharge at the end of the day. Yeah. The thing that raised when we talk about credit reports that's interesting to me is taxes. There are other alternatives to filing bankruptcy, but if you do some type of debt consolidation and other things, you gotta be careful, right? I mean, if you owe $1 million and you pay back $100,000 and you agree, you're gonna have to pay $900K. You're gonna pay that delta, that $100K in income. If you discharge it in bankruptcy, there's no tax consequences for that. So there are good reasons to file a bankruptcy if you qualify and it makes sense, because you don't have to pay that tax. I mean, you're not taxed for it, right? If you compromise with the bank, you have a home, a second or something, and they say, okay, you owe 300, but we'll take 100 to go away. They'll send you a form at 1099-C or something like that for the 200. Now you have $200,000 in income you have to pay.
Yeah. Got it. So it sounds like there's a lot of different strategies that can be used with bankruptcy itself that can be amazing tax strategies to actually help you save money.
Yeah.
So basically, if it sounds like if you're struggling with any creditors or you just have a high amount of debt and you really just need to kind of look at the big picture, and it might be even good to just have a conversation with a bankruptcy attorney to see if there's any options that could help you out, whether that's for individual or for business.
Right. For a lot of times, bankruptcy attorneys on the debtor side or creditor side, I mean, they'll talk, and usually it's free consultations. If it gets far more complicated, like for a business, I mean, there's fees for that to evaluate it, but that's the normal course for any type of case like that.
For sure.
I think, my work is mostly on the creditor side, where firm does both debtor and creditor work. The valuations are very similar. You have to know both sides. And so a lot of it's just understanding the process and doing the work before someone files bankruptcy if you're a creditor trying to protect yourself. And the debtor, same way, planning strategically, correctly, knowing what exemptions you're entitled to and not. And all of that is kind of the process, right? You have to be diligent, you got to have good financial records, and you got to hire someone who's good.
Got it. Okay. And then on the negative side for when it comes to businesses, what are some of the negatives for filing for bankruptcy? Because I mean, like from what we're talking about, it doesn't seem like there's really that many negatives. It's like, I can't afford to make the payment. I'm being honest about what my numbers are. This is realistically where we're at. I just can't do it anymore. And it sounds like it just helps to discharge that one debt or multiple debts. And it really is the right thing to do if you're just not in a position to survive.
Yeah. So with the reorganization, I mean, at the end of the plan, you get technically a discharge, but they don't want to call it that, right? That stuff goes away. But if it fails, I mean, you're seeing it in the news, right? Like, if it fails, I mean, it fails, then maybe there'll be a fire sale of the assets. Yeah. It'll go under. Usually there's a lot of lenders with security, loans, and they're going to take over everything because they have a blanket lien on everything. Yeah. Businesses are very much different beast. But the negative tends to be a blowback against the owners and officers, right?
Yeah, because it looks bad, right, to the public eye.
And or maybe they stole money, or maybe they had breached their fiduciary duty.
Got it.
But the duty, as a debtor's attorney to a company, your duty is to the company, not to the owners and officers.
Yeah.
And so they have their own counsel. With a small business, people blur that line, but the bankruptcy court treats it very seriously.
Yeah, I guess I'm assuming when I make that statement that I'm saying it's a trustworthy company that's not doing shady shit, for lack of a better term. But of course, in companies where everything's going smoothly and then there's a problem, it usually means that somebody has done some major wrongdoing, right?
Not necessarily. I mean, businesses, I mean, this is the beauty of our system, right? That businesses fail all the time, and it doesn't take you under for the rest of your life.
No.
As long as you didn't commit fraud or do anything shady. I mean, they can fail for normal, market reasons.
Got it.
And so if that company fails, it fails.
Yeah.
It's bad, but obviously there's a human toll for that, right?
Yeah.
And that's not taken into account. That's because it's not the economics of it, right? There's employees, the owners, the livelihoods, of course. And those are real concerns. Those are probably the bigger concerns.
Yeah.
But the bankruptcy process doesn't heal that. It's not what it does.
No, not at all. And I mean, like, when I'm just like listening to this, right, like even for the creditors that are having to deal with bankruptcy, it's like, this is just also the cost of doing business. It's the risk of working with certain individuals, right? And it's not everything is going to be a guaranteed slam dunk deal. Just like even in my business, not every case I work on, we make money on, right? Some are losses, and we take that risk into calculation. And, this is why credit scores and things like that are so important, because they give you a decent reflection of where that person is as a human being, and then using things like collateral helps to make those deals a lot better. But from what you're saying, we really do have some solid protections when it comes to our assets, or at least the real estate assets in the state of California. Are there protections, just out of curiosity, in regards to like your car or like a boat or something like that, or really is like the home the major exception for like protecting your asset?
Yeah, the exemption, the way the exemptions work in California is there's like two sets, they call it, and it's based on the Code of Civil Procedure, but there's, a 703 and 704, which just gets everyone's eyes glazed over. But yeah, there's, depending on, if you have a home, to get the homestead exemption, I think you usually file the 704s. Hopefully I'm not flipping them. If you don't have any real estate, you usually do the other exemption scheme, because it protects like personal property more. But there are two different schemes, and they protect a bunch of things, mostly the home, sometimes clothes, personal injury claim, and things like that. But they do have a complicated and it's a long list, and that's the type of planning you have to do beforehand, right? Once you know the lay of the land of your assets and what you have, you can figure out what exemption scheme to protect that. Like it protects an exemption, effectively takes that amount of the asset out of the bankruptcy case, right? So if you have a bank account and you're able to exempt, say, 2,000 of it, and it's a 2,000, that bank account's, I mean, you disclose it because you have to disclose it, but no one's touching that 2,000 now. That's kind of protected. So exemption planning is very helpful. And you're right, it's mostly the home. Cars have it depending on if it's used for work and so forth.
Okay.
But a lot of times you kind of have to, pay the lender, right?
Yeah.
And go from there.
Of
You
course,
are
'cause
seeing a lot
you
of
want to
reasons.
keep your vehicle.
Yeah, 'cause you need it for
gotta-
work.
You got to keep paying for it. Yeah.
Yeah, especially in California, especially down here, you have to.
Yeah.
It's hard. I mean, maybe people are working from home, but those tend to people have higher income jobs, right?
Yeah.
So
What about like second homes, like that are like investment homes, and maybe like let's say I have my home, right?
just for a friend, right? This is you're asking just for a friend?
Yeah, I'm not there yet. I wish I was there, but basically, let's say that you own your home, you have 500,000 in equity, and so that's going to get qualified to be protected.
Let's assume it is. Yeah.
Assume it's that, and then you have another home, and let's say two scenarios. One is a house with 500,000 in equity. That's my second home, and then another scenario where I have $1 million in equity. What would happen in those two scenarios?
Yeah, it's a great question. So, if your primary residence, your homestead, you could protect the homestead, and there's reasons for you want to stay in that house you've lived in the last 2 years and so forth. There's a test for it. Your investment properties, it's just an asset.
So
there's no yeah. So I mean, it actually does matter because they might get sold, right? But there's no exemption to protect it. So if let's say you only had two assets for whatever reason. Your home is protected, but you have 500K of equity in your investment property.
Yeah.
You have 200,000 of unsecured debt to pay creditors. That will get sold to pay those creditors. You'll get the delta.
Yeah, of course.
But it's going to be sold to pay it if you.
Delta means the extra of whatever's left after you pay off your debts.
Right.
Okay, got it.
Yeah.
Okay, cool, awesome. I just want to look at my notes real quick to make sure I covered most of the topics. Yeah, please.
Is that because delta is the symbol for change?
Yeah, sorry. It's funny you use these terms and you're like,
Right.
oh, that's just yes. So it's just the difference between the two. Like if it's $1 million property and there's a $400,000 lien, the delta is the difference, right? So 600 is equity, so that's yours. If you have to pay, if you have 300,000 unsecured creditors, then you subtract it from there. Yeah. I assume that was just for us, right?
Totally, but also kind of,
Okay.
One sec.
I know you wanted to talk about those other chapters, but I don't know if you want to get it. They're
No.
Yeah.
We don't. We've covered pretty much everything that I think is important for the main stuff. This is not to get into the weeds.
Yeah.
You and I could always talk about the weeds another time.
Yeah, unless you know some family
Yeah.
fisherman or something
'Cause
like
you also
that.
got to remember this is not unless somebody's really interested in bankruptcy, you know what I mean?
Yeah.
I don't think they're going to listen to it longer than an hour and a half is my thoughts on a topic like this.
Have we been going for that
Yeah,
long?
we've been going for an hour and a half. So that's what I'm
Okay.
saying. I'm conscious of what people's minds are willing to probably dive deep into a topic. So unless you have some ridiculous stories, I would like to hear those of some really fucked up shit that happened during bankruptcies. You obviously can't give the details.
I do, but that's for offline. I
can't?
can't.
Yeah,
No.
okay, got it.
Yeah.
Okay.
Yeah.
Got it.
Because they can always come back at you.
Yeah, no, I understand. That's
Yeah.
why I was asking. If
Yeah.
there's a way of doing it where you're not telling specific situation, then great.
I
If
can
not,
tell you non-client stuff, non-specific, but offline still.
Yeah, I understand. Yeah. So that's what I'm saying. I'm trying to figure out what's left here that I want to ask you for the podcast. I have a list of questions. We've covered pretty much most of them. I think I don't think there's anything I haven't covered that I have questions about or that I wrote down.
I just have random personal questions for you, but we probably don't need to get into that because I don't know how you're going to weave it in. We can just talk offline or get lunch another time and do it.
We can talk a bit at the end. That's not a problem.
Yeah.
Okay, so I think we've talked a lot about bankruptcy. We can kind of segue into this stuff, but I just kind of want to like understand like just like a summary of everything. But it sounds like whether you're filing for as an individual or a business, if you're in a situation where you have more debt than you can afford, bankruptcy actually sounds like a great option. Sounds like it helps you to restructure your debt. It helps you to start over, and you can basically start rebuilding your credit score, and you can help to save your business. And from what I've heard here, as long as people are not doing fraudulent actions and lying about what they have, this is actually a great tool that can really help people out to start over. Does that sound about right?
Yeah. So tips to take away, like exactly what you said. It's all about disclosure. So being honest, having detailed records, understanding why you're filing and what your goal is afterwards.
Yeah.
Right? What's the purpose of filing, and then having competent professional help you through that process. And if you can, have the time to do it as opposed to responding to an emergency and then just filing.
Yeah.
Yeah.
Cool. Okay, awesome. I know we know each other through Provisors. So Provisors is this networking group of individuals where it's like white collar professionals, everything from like lawyers to real estate people to financial individuals. How's your experience been with them?
I like it. No, Provisors has been pretty good. Like starting your own firm, you always wish you did it, earlier, right? You always, it goes well, well, you only hear from the people who goes well though, right?
Yeah.
So
The rest you don't hear about.
Right. But you always say, I wish I did it 5 years earlier.
Yeah.
So, I wish I joined earlier, but it's been great. I've enjoyed it. I've met great people, of course, like yourself and others, and some close friends from it.
How long have you had your own firm now?
Oh man, don't quote me on that, but it was during COVID. So my partner and I have been together for the whole time. And we finally buckled down during COVID to just formalize what we've already been doing.
I mean, you guys like worked together before?
Yeah. No, worked together as my whole career, legal career. So so we do the same stuff we were doing when it was his firm.
Yeah.
So we kind of buckled down during COVID when we had some time. So, all right, let's formalize this.
Yeah.
And we could have done it earlier, but we were just busy. The usual.
Yeah, I guess. Yeah, my journey was a little bit different. It's like when I passed the bar, I applied to like a couple hundred firms, and I got like 2 job offers, which were like wouldn't support anybody. And I was
this
just
during the recession time?
No, dude, this was just 2014. And I just like didn't get any reasonable job offers. And I was like, you know what? I always kind of wanted to work for myself. And I was like, you know what? I'm just going to go for it. And I just kind of went for it right out of law school.
Nice.
And that was a very painful experience, to say the least.
Hanging your shingle on your own.
Starting because if I had known that I was planning on starting a firm, I probably would have stayed at an internship for longer and really learned the details of how to run a business. Because like being an attorney and running a business are completely different things.
Yeah, different skill sets.
Yeah, and they don't teach you. One is 2 things. One is running a law firm is just like running any other business. So like I think a lot of people say, oh, the law firm, it's different. But businesses are businesses, I think, no matter what genre you're in. And so you go to law school to learn how to be a lawyer. And you can even argue a lot of time that they didn't teach you how to be a lawyer. They taught you the theory behind the law, and then you had to go work at law firms to learn how to become a lawyer. So, I'd worked at a couple of PI law firms, and I worked at different firms. And so I kind of learned a little bit. And then when it came to starting my own practice, I was like a chicken with my head cut off. And when they say birth by fire, just figuring it out as you go along, like if there's one thing that a lot of people ask me, like why I'm like good at the things I do, it's because I failed at everything. And I failed as quickly as possible. And I just went as fast as I could. And it was like for a long time, I was kind of stubborn about hiring employees. So like for the first 3-4 years, I didn't have anybody that worked with me. And so I just did everything myself. I was the intake person. I was the case manager. I was, like sending the letters of reps, sending out mail, doing my disbursements, doing my accounting. So like, I think there also just comes like a certain amount of respect with my team. Because, obviously I have now 10 full-time employees. We're doing great. There's things that are awesome. And they all do a specific job. But, like, when they're not able to do it or they're busy, I just go in there and do it. And I think it's, like, you gain, like, a little bit of respect because it's, like, no, I've done this job. Mm-hmm. I've represented hundreds of cases on my own without any help. And, like, there's just, like, I don't just ask people to do it because I'm not willing to do it. It's just, my time and my resources go to better directions.
Yeah, to keep the firm profitable.
Yeah.
Absolutely. That makes sense.
Yeah.
Do you regret the decision? Not the decision. Do you regret that process, or in hindsight?
If I could go back and tell Joe, I would tell him to go find the top litigation firm in Southern California, which for me would be like Payne Shea and Boyle, and I would say beg them and show up every day with like gifts for Brian and for his team, and just beg them to let me work in their firm for 2 or 3 years and just learn how to do it from the best. Because all of the best knowledge and experience that I have is from like co-counseling and working with these top firms that I work with a lot of times now. And I wish I could go back and just tell the younger me, just go buckle down. Don't even worry about getting paid for a year or two. And like, you'll figure it out as you go along and really learn from them, because like, it's great that I had the experience and I figured it out along the way, but to learn from somebody who's already doing it the best and is so experienced and so good at what they do would have been invaluable for me. And it would have been a different life path. But also I think it made me just so much more willing to be riskier on things. I think it made me so much more willing to go for it. I think I have a much harder work ethic because I just said, if I figure out a way to make money, I'm not eating, you know what I mean? I can't afford it. Like, if I want to pay for these things, I got to figure it out. And so I figured it out, and I definitely always found a way, and it definitely made me push harder and work harder in those ways. But yeah, I would have liked to see what that other alternative route would be. But then again, I might have gotten comfortable. And I might have just been happy at a job, right? And then I maybe wouldn't have started my own firm.
Yeah, that alternate example, alternate reality, you already know what this one was, and you're successful. But that one might have been good up front, but you have no idea where that life path would have gone.
Yeah. So I mean, I figured it out. I just, if I could go back and tell myself, just maybe go learn a little bit more. But nonetheless, I think I'm also stubborn, and I might have just been like, no, I'm just going to start my own firm and I'll figure it out. So I could have just had the same result even if I did go back and talk to myself.
Are you seeing changes in your industry, like over the last couple of years or anything? Is it changing the way you guys are practicing, or is it?
I think like one thing I'm really paying attention to is like with AI, right? Like I have a Tesla. The thing is, like, I love my autopilot, but my autopilot is not perfect. And I feel like I definitely drive safer than when I have the autopilot. Like if I'm on a long drive, I'll use it. But if I'm like on side streets, it's not safe enough in my opinion. It's still like kind of jittery and stuff. So I definitely see in the long run, maybe like 5-10 years from now, most cars will have some sort of autopilot. And, as this happens, it's going to be great for people because there's going to be less accidents. They're going to be less severe because you have early warning systems, and that's all good stuff. But I also have to be cautious of the fact that there's going to be less business, and there isn't going to be less attorneys because there's just more of us popping up all the time, and everyone's competing. And so I'm just cautious of the fact that there's going to be less accidents. It's going to be safer for people. And then at the same time, I need to just get so good at my job and be such a staple in my industry that even if there is less business, we're still thriving and we're still doing good. So I'm just paying attention to those nuances. As for like changes, major changes in California, we finally, for the first time in 50 years, went from 1530 policies to 3060. So by the end of this year, everybody will now have at least a 3060 policy, which is double the amount that it's been since, the late 50s, I believe.
Oh, interesting.
Yeah, that's going to be huge for clients because you go in a hospital, you go in an ambulance, you already spent most of the money on the entire case for your treatment just from that one trip. So now it at least gives people a little bit more leeway where they can get paid a little bit more, and also they can finally pay for their vehicles because no one's driving around anymore with a car that's worth less than $5,000-$10,000, which I think were the minimums on the previous policy. I think it's like $15,000 now is for property damage, which is great. And I might have misquoted that. I'll have to double check, but the numbers have gone up significantly, which is great.
Nice.
Yeah. Is there any major changes that have been going on in your industry lately?
Most of it is just on the political end with the changes, which we don't have to get into. But yeah, I mean, bankruptcy code I think was modified in 2005, and there's just been incremental changes since then. So they're probably due for some reform. But the changes are just more of the economics. Bankruptcy is kind of that funny inverse or perverse thing where when the economy goes bad, the bankruptcy attorneys do well, right? Yeah. So we've been saying there's going to be a downturn for a while, but things have been good for 15 years. Yeah. Or not 15, but it's been good for a while. If we keep saying it, it'll eventually happen. But
what do you mean it's been good? Like good for you or good for clients?
Good for the economy, right? The economy's been decent. Bankruptcies have been down for a long time.
Yeah.
That's a net good. Bankruptcy attorneys, based on stats and things they've seen in retail and real estate, think that, there's going to be a downturn for a long time. Yeah. It just hasn't happened yet.
Yeah.
So.
Yeah, at the Tony Robbins conference that I went to recently, a lot of the financial projectors, like guys like Ray Dalio, Steve Forbes, there has to be a correction at some point. We can't just keep going up forever because the numbers don't make sense since we're basically stacked on so much inflationary money. So, right, you have Biden who pumped in $11 trillion into our economy. Like the way that economies work, from my basic understanding, is, you spend money that allows people to spend more money that are having products bought from them, and that also allows them to get more credit. So as long as there's more spending going on, then the economies keep growing. But now that we're not pumping $11 trillion into the economy and hopefully not just giving away a bunch of free money anymore, we're so inflated because of all that money that was just printed and poof out of nowhere that there has to be some correction because all of our numbers are just not realistic. So hopefully it's not a major depression, because there were some projectors, one guy named Harvey Dent and this other guy that's just like, look, we're going to have a major crash. And they're like, it's going to be as bad as 1929 because the numbers just kind of show that. But the difference is between this and 1929, in my opinion, I'm not a financial projector, is just we didn't also pump $11 trillion into our economies, and all the governments didn't do it all simultaneously, right? It was like the US had a problem, but it was a whole world problem with COVID that affected everybody. And so it's going to be a completely different scenario. So I think a lot of it's going to depend on how the U.S. plays things out, because our economy affects everybody else. And it's going to depend a lot on how Trump and Elon, it seems too, are going to figure out how to handle this whole situation. If they can cut our debt significantly, what a lot of the financial projectors are saying is it will buffer it. We're still going to have a correction because it just, the numbers don't make sense, and you can see the arches of the bubbles. Like you can literally see the bubbles on all the projections, but until they're going to hopefully soften our landing. And things like tariffs that everybody is so angry about, they're actually fantastic for the long-term play, because what Trump is trying to do is he's trying to bring money and he's trying to bring economy and industry back to America. And for the short term, yes, Americans have to pay a little bit more on some stuff, and it costs us more money, and it's causing a little bit of relationships with these bad relationships with these other countries. But when you look at big picture, it's like a lot of these economies depend on the US to buy their shit. We don't really buy a lot of their shit, like in like they don't buy a lot of our shit and vice versa. So when they put a 25% matching tariff on us, it doesn't really hurt us that much. So what he's doing is he's telling those countries, look, you've taken all your businesses out, you build in these countries, and you save money by doing it. I'm going to make it so expensive that you have to bring your businesses back to America. You have to build it here, and you have to bring the jobs here, and you have to bring the money back in our country. Because right now, all the money is just getting siphoned out to these other countries. So it's actually an amazing long-term play. It ends up making more money from our government, and the more money that our government makes, the hope is that they need less from us in taxes. So he's doing a lot of long-term plays. And, as for Trump as an individual, he is who he is, and I don't want to comment or really get into details about that. But I think actually from a business standpoint and what he's doing in regards to the economy, I think is actually really wise. And so I think there will be some more bankruptcies, and not to say that in a way to scare people. It's just you can't spend money forever. At some point, people are going to call in the debts. And when the debts are being called in, if you're not making as much, like it's just, there has to be a correction. It's just the balance of life, ups and downs.
Yeah. I mean, I love economists, but I don't know if they've been right for a very long time. So I guess it's always a we'll wait and see, you know, one year at a time.
Yeah.
I hope you're right, but I'm not qualified to talk about. I have no idea.
No, for sure. I literally, this conference was one of the best things I've ever been to in my life. Like, it was awesome. Like, there's guys managing $500 billion funds. Like, these are the top, like, financial guys in the world. And it was really special to be a part of this, like, Platinum Partners thing. So, like, I obviously have limited information, but after leaving that, I feel like I have, a little, almost like a Bachelor of Arts or Bachelor of Science in finances and investing, because they just gave us so much information for, like, 6 days in a row for, like, 14 hours a day. And so it was really awesome to be able to see these top people really just kind of giving us advice on what they think things look like. And just like you said, they're like, we don't guarantee anything. We're just giving you what we think based off of our experience and being in these industries for 40 years and just realistically what the numbers are showing. And so it was all very statistic based, which I love. I'm just all about the numbers, what actually makes sense. How does this all work? And so it was good. They have they project bright futures for America, but it's just there has to be some sort of correction at some point. Yeah.
Well,
cool.
From your mouth to God's ears.
Yeah, right.
Yeah.
All right, so let's go ahead and wrap this up. And I want to just ask, what is one last piece of advice or just one last thing you want to leave our guests with? Maybe a quote or just something about your industry, anything you want to go ahead and wrap this up.
I just want to thank you for your time and this lovely studio, and I appreciate the opportunity to speak with everyone here and speak with you in particular. And I just, on the bankruptcy front, it doesn't have to be scary. You just have, just be diligent, have a good professional help you, and just have clean financial records. And it's all about being honest. So my advice is the system is there to help you, and you just got to have, you got to take advantage of it to your benefit and have someone good to help you through that process. You shouldn't do it alone. That's for sure.
Yeah. Okay. With that being said, if anybody needs to contact you, how can they reach out to you? Or if they have questions on bankruptcy, obviously you're a California bankruptcy attorney, but do you do bankruptcies in other states?
I'm a certified specialist in bankruptcy law by the State Bar of California, Board of Legal Specialization. They make you say the whole thing. So yeah, I mostly practice in California. I have a mixed practice of like insolvency work and creditor work and state court litigation. So that's where we do a lot of kind of the superpower we have is that we're able to bridge the gap between state court and federal court, and we know how that interplay works a lot. And I do have cases outside of California, but they usually are on the creditor side or defense cases, not bankruptcy cases, at least that we're filing.
Okay, cool.
Yeah.
And how can people reach you or contact you?
Yeah, it's, type in Salvador Boufadel, and you can find us on our website.
You want to spell that?
Yeah, put it in the show notes.
Yeah, we'll put it in the show notes. Actually,
Okay.
just look in the show notes. It'll be fine. It'll be in there.
Yeah.
And then if there's a phone number, are you okay with people reaching out to you directly, or would you prefer they call the firm number?
Yeah, the phone number is, they can just email me is the easiest thing actually to do.
Okay.
And it's an annoying email address, so we'll just throw it in the
We'll
show
throw it in the
notes.
show
I tell
notes.
that to clients all the time. It's like, let me email you. I have
Okay.
a long, annoying email address.
That's funny. Okay, perfect. Well, guys, thanks for chipping in. Thanks for tuning in today. This was an amazing conversation. Thank you so much for sharing and kind of just like working through a lot of the myths and a lot of the illusions that I had about bankruptcy, and also just, I guess, the negative connotations that I had about it. I thought it was some horrible thing. You're going to be screwed. You can't get a credit card. Your credit is destroyed. But it sounds like almost similar to like debt settlement. My dad owned a debt settlement company for a long time. It's like you're just getting rid of the debt, and you're just negotiating it and you're paying it, and then your credit starts going up immediately after. But these are great tools that if you're interested or this is something you're thinking about, reach out to an attorney, speak to them. And thank you so much for sharing your knowledge with us today.
Of course, and thanks for having me. It was a pleasure.
Awesome. Everybody have a lovely day. Thanks for chiming in.
Take care.